Have you ever wondered about the intricacies of the EU's migration and asylum policy? Imagine a system designed to manage both legal and illegal immigration flows, a system that is at the heart of the European Union's approach to immigration. The policy is a complex tapestry woven from various principles and regulations, including the Dublin Regulation. This regulation plays a pivotal role as it determines which EU member state is responsible for processing an asylum application. The policy is not just about managing who comes in and who doesn't. It's about upholding the EU's commitment to human rights and international law, while also maintaining the security and economic stability of the Union. It's a delicate balance, one that requires careful navigation between the rock of legal obligations and the hard place of practical realities. This policy, while comprehensive, is often a subject of debate and controversy. As we delve deeper, we'll discover the reasons behind these debates and the potential implications they hold for the future. Now let's delve into the cornerstone of European law relating to asylum, borders, and immigration. The backbone of these laws is formed by two main sources: the Geneva Convention and the European Union's Charter of Fundamental Rights. The Geneva Convention, adopted post-World War II, defines who is a refugee and sets out the rights of individuals granted asylum. On the other hand, the EU Charter of Fundamental Rights, which is legally binding on all EU institutions and bodies, enshrines civil, political, and social rights of all individuals, including migrants and refugees. Moreover, the European Court of Human Rights and the Court of Justice of the European Union have further shaped these laws, developing common principles such as non-refoulement, which prohibits the return of individuals to countries where they face danger. These laws and principles are designed to protect the rights of individuals and ensure fair treatment. What are the obligations of border authorities and member states towards refugees and migrants? A question that's at the heart of Europe's immigration discourse. The fundamental rights of refugees, asylum applicants, and migrants at the European borders are enshrined in numerous international conventions and European Union law. These rights include the right to seek asylum, protection against torture, inhuman or degrading treatment, and the right to a fair trial. Border authorities and member states have the obligation to respect these rights. They must also uphold the principle of non-refoulement, which prohibits returning individuals to a place where they face danger. Alongside these obligations, border authorities and member states carry the responsibility to respect human dignity. This means ensuring safe and humane conditions for those held at border facilities. Far from being optional, these obligations are central to ensuring the humane treatment of individuals seeking refuge or better opportunities. How does one legally migrate to the EU? What are the criteria and conditions? These are questions that often arise when considering a move to the European Union. The EU regulates legal immigration through a variety of means, taking into account different categories of migrants. For example, workers may be eligible for the EU Blue Card, a work permit for highly skilled non-EU citizens. Students and researchers also have specific visa categories based on their academic or research pursuits. Family members of EU citizens or long-term residents can apply for residency under the Family Reunification Directive, which allows them to join their relatives in the EU. Long-term residents, generally those who have resided legally in an EU state for 5 years, also have specific rights and privileges. Understanding these laws and regulations is crucial for anyone considering migration to the EU. This knowledge empowers individuals, enabling them to make informed decisions about their migration journey.
Subscribe, share, like, for enhance your legal knowledge.